whatever public side entity you were using to be able to tap into this world of commerce that was created for us, you'd always make sure it was operating in extreme debt, because you always want to make sure the trust is the first line, first served. If there is somebody does decide to have a judgment against you for something, that they can't get anything from you. Even if there was money there, they couldn't get anything from you because that money's first owed to the trust. Ideally, once you get in going down this path, you never operate out of that public side entity again. You don't have to do anything to dissolve the contract. Just let it bleed. Let it bleed. If you need to get sued for something, give people that name. You don't give them your trust's name. I mean, they couldn't really do anything to you anyway, because we put ADR provisions in our trusts where if ever does come down to a court battle, the first thing that they see is, alternative dispute resolution. We got to go meet in the law library instead, get this out of the chambers, make sure, as the trust explicitly notes, that there's no bond needed for the trustee, and the trustee just comes in with a hat. It could be the same. It could be somebody's suing me in my public capacity, and they want to bring me into a courtroom, but they don't realize that I'm signing the documents as the trustee and the chairman of a board of a trust that has the same exact name. And my only function is to go in there and balance the books and have a meeting of the minds and reach some kind of settlement. Now, immediately the court knows that, we can't get any money out of this guy. We can't hold his body as surety. We can't put him in a debtor's prison, right? Can't do that because because the terms and conditions that this new entity that we're operating under, and it was obviously a case of mistaken identity, because how can I be that thing that's on paper if I'm this thing, right? Operating in this capacity with this agency.